The Honourable David Parker.
Mr. Chairman, I have a question for the Minister relating to clauses 59 and a separate question in respect of clause 61 of the bill. Sir, 58 and 59 together. Sir, clause 58 and 59 of the bill relate to amendments to New Zealand legislation to provide mutual assistance to overseas countries who are looking into the sorts of things that would be illegal in New Zealand. The first question I have in respect of clause 58 of the bill is the new section 31, which is inserted into the Principal Act, which is the Mutual Assistance in Criminal Matters Act 1992, says that a foreign country may request the Attorney-General to assist in arranging the taking of evidence in New Zealand, and the Attorney-General can authorise that assistance if it's satisfied that the request relates to criminal proceedings in that foreign country and there are reasonable grounds for believing that evidence can be taken in New Zealand. And I can see why that power is necessary. My first question relates to why it is that these rights go to the Attorney-General rather than sit with the police. It seems to me that these things ought not to be elevated to so high a level that in practice there are procedural impediments to actually cooperating with foreign countries trying to stamp out these sorts of corrupt practices. It may be that there has been proper thought given to that and that there are the reasons for leaving that with the Attorney-General relate to the fact that it's the Attorney-General who, through Crown law, generally exercise those prosecutorial decisions, but it's also could be argued, I suppose, that in respect of lower levels of criminality, which nonetheless ought to be policed, it's generally the police that exercise those questions of discretion, sir. The second issue that I have not yet had an answer to from the government, ministers and the chair, arises again in respect of clause 59. I raised this issue in respect of my contribution in part 1 of the bill, and that relates to the definition of what is a foreign public official. You'll see that in clause 59, schedule 1 is amended by inserting into the list of offences against the Crimes Act the new 105D, which relates to bribery outside New Zealand of foreign public officials. And I asked why it is that we've got such a narrow definition of a foreign public official that it doesn't capture the sort of controversy that we have currently in respect of the Saudi sheep issue. Now, I accept that the government does not accept the opposition's characterisation of the payments that were made to the Al Khalaf Group, a $7 million cash payment, which the opposition and the media think. I'm still talking about this. That's the reference we have from the National Party. The National Party that refused. Human trafficking and sheep trafficking were the same thing. And this is irrespective of whether you think that the Labor Party characterisation of those payments is accurate in fact, I would have hoped that the National Party would concede that if we are right in fact, those payments are improper. A $7 million payment, if it really was to buy the cooperation of the Al Khalaf Group in order to to stop that person blocking advancing the free trade agreement with Saudi Arabia, that is improper in my book. You can have a factual disagreement as to whether the facts actually show that that was the purpose of the payment, but if that was the purpose of the payment, and I think it was improper. And that sort of payment ought to be illegal under New Zealand's law because it is improper. But the problem with this legislation is that that sort of payment, even if it is made, is not made illegal because you've got such a narrow definition of what is prohibited to be bribery of a foreign public official that it doesn't capture that sort of payment. So if Mr Al Khalaf was paid that sort of payment and it was improper and he was a public official, it would be caught by this legislation. But if he's not a public official, Mr. Chairman,
Honourable David Parker.
but if he's not a public official because not a public servant, he's just someone who's got influence on public servants, it's not caught by this legislation. And we've yet to have an explanation from any minister in the chair as to what is the logic behind that proposition. And having not had an answer on part one, I'm hoping that we get an answer in part two, because it arises in respect of clause 59 of the bill, where where section 105D is inserted in schedule 1, and what's inserted is relating to bribery outside New Zealand of a foreign public official. And I make the point that the definition in this bill is so narrow that the situation that we have in respect of the Al Khalaf group would not be caught, because Mr Al Khalaf is not a public servant or a foreign public official in that context. So, irrespective of whether the government agrees with my characterisation of what Mr McCulley and his government did, the theoretical possibility that you can make those sorts of payments legally under New Zealand law is, in my contention, is wrong. So, could I turn also to, funnily enough, sort of the flip side of the what I've been saying in respect of clause 61, which inserts provisions relating to international policing and information sharing to assisting the corresponding agency overseas. Can I just note a degree of caution here, which I hope that the government has properly taken into account? And that is, and we've had experiences in this parliament in recent years, and not just under the current government, also under the prior government, this isn't a political point, where overseas governments that aren't very good at preserving civil liberties actually at times take what are quite political prosecutions or attacks against members of their own population for political reasons. And we've got to be a bit careful that we enable our police to pass a sniff test across what's being asked of them in pursuit of allegations of corruption in their home country, because sometimes it is not what it seems, and sometimes what can be happening in those other countries is actually oppressive of some of their own citizens. So we have to retain a discretion on the part of the police as to whether they think they should be assisting their corresponding overseas agencies, because on some occasions I would actually trust the New Zealand police to say, actually, no, we don't think we should be assisting in this particular prosecution, because this particular prosecution or the country overseas have endemic corruption in their own country, and we ought not to be letting them use the New Zealand authorities to assist with politicised prosecutions that aren't grounded in actual corruption. Now that's a hard thing to do, to legislate for, and you actually can't specify every eventuality in writing, but you do need to make sure that the police have a discretion, in my opinion. We need to trust the New Zealand police to actually sort the wheat from the chaff and to exercise their responsible to responsibly exercise a discretion as to whether it is that they cooperate with the overseas authority when that foreign country wants to have the assistance of the New Zealand police in order to gather information relating to a prosecution in that overseas country. Thank you, Mr. Chair.
I call Mekawhai Terry.